Hello, my name is Clarissa Allen, and I was a colleague of your professors at McGill University in Montreal, where we both did graduate work in biomedical ethics. Currently, I'm a lawyer for the federal government in Canada, where I advise judges of the federal court, perhaps most notably on patent disputes in pharmaceuticals. Today I'm going to be presenting two lectures. The first will be a general introduction to legal issues that might be relevant to you in your careers as health practitioners in the field of genetics. And the second is going to be a little more narrowly focused on human gene patents. In the first lecture this morning, I'm going to start by giving you some background on the legal instruments that have a role to play in regulating genetic medicine and research in the UK. And then we're going to consider these legal instruments in practice through the discussion of a case study based on the Henrietta Lacks story that you learned a little bit about through your readings for this week. So let's get started. So I'd like to first recap a distinction that Catherine raised with you in previous lectures, which is the distinction between law and ethics. So many scholars and practitioners like to talk about ethical, legal, and social issues in healthcare in terms of rights. Some that you've touched on maybe already include the right to healthcare itself, the right to privacy, to confidentiality, sometimes rights to certain types of information come up, even the right to not be informed with regards to some types of information. Another is the right to ownership in your own body, or perhaps to the benefits that arise from the study of your body and its tissues. So in this context of discussing rights, it's useful to distinguish between moral rights and legal rights. As I've indicated in the slide here, moral rights can be defended via philosophical paradigms. As you see, some of them are listed: Aristotelian virtue ethics, Kantianism, utilitarianism. And while we could spend an entire semester discussing whether such rights are universal or their exact ontology, I think most people would generally agree that such rights are not easily circumscribed within limited jurisdictions in the way that we know the law to be. So up until this point, most of what I take it you've discussed will have been focused on these kinds of rights, so they should be somewhat familiar to you at this point. In contrast, in this lecture we're going to be focusing more on legal rights. So this type of right is generally identified in the legal instruments like legislation and case law, and as I mentioned, they are jurisdiction specific, by which I mean, generally speaking, that laws, for example, that apply to British citizens while they are in Britain are not applicable to Canadian citizens while they're in Canada, and vice versa. Another important distinction between moral rights and legal rights is that legal rights are enforceable in a way that moral rights are not. So they create enforceable duties and responsibilities, particularly with respect to the state. So when we're thinking in terms of practical consequences, legal rights are often more immediately relevant than moral rights, given their potential consequences. One thing to keep in mind, though, is that while moral rights and legal rights are distinct concepts, there are, as you've probably noticed, a lot of overlap between them. So patients have, for example, a moral right to not receive medical treatment or to participate in research without their informed consent, and this is based in the moral concept of respect for autonomy. Patients also have a legal right to the same thing. In this case, it's founded in both the common law jurisprudence and in legislation, which we're going to be discussing shortly. So there's a lot of overlap between legal rights and moral rights, and of course they influence each other quite significantly. In an ideal world, we might hope that laws would provide a mere reflection of ethical principles, but of course this is not the case. One practical reason for this is that ethics is a much more responsive and flexible field than law. So scholars in the domain of ethics can move more quickly to respond to emerging issues, to develop principles, best practices, that kind of thing, that apply ethical norms to new technologies. In a field like genetics, where innovation occurs at an exponential rate, this can create quite a gap between law and ethics. That said, there are good reasons why law moves considerably and sometimes frustratingly more slowly than ethics. This is, of course, that the consequences of illegal behaviors are often much more severe than the consequences of unethical behaviors. So law dictates the distribution of resources and controls people's freedoms in a way that ethical norms generally do not, which means that we have to be more careful, more cautious as a society in crafting and enforcing laws. That said, without getting into too much legal theory, I'd say that it's generally agreed upon that law ought to be grounded in ethical norms. So let's move on to discussing some of those legal instruments and how they relate to the field of genomics. There are a number of sources of law that are relevant in the medical context. Each one has a variable degree of authority. So we're going to start at the most universal level in terms of applicability, where we have international instruments, including the ones that I have listed here, declarations of the type articulated by organizations like the United Nations and the World Health Organization. Well, these instruments are broadly applicable in that they inform many more specific national or regional legal instruments. They're generally not particularly binding. So it's useful to think of them as describing a sort of high-level legal norms which are reflected in many more specific and more authoritative legal documents. Where gaps exist in more binding legal instruments, these norms might provide some useful direction. Next on the ascending list of authoritative sources of law is jurisprudence, both that of the UK itself and, for the time being anyway, that of the European Union. So the UK is a common law jurisdiction, which means that its primary source of law is made by judges deciding cases in court. So that means that the decision of one judge on a particular matter, assuming it's not overturned by a higher court, becomes precedent that is binding for future cases involving the same issues. Decisions of the Court of Justice of the European Union can also be binding in the UK if a matter is relevant across the EU. Discussing jurisprudence brings us to our next source, which is legislation. Legislation is on par with jurisprudence in terms of enforceability, and in fact it often arises from jurisprudence in common law jurisdictions. So where case law in a particular area has become settled, it will often be encoded in a piece of legislation for ease of accessibility, for better organization. EU directives are also relevant in this context because the EU has declared its laws to be binding on member states, and in response, the UK has decided that those laws are enforceable without the need for ratification or incorporation into national laws. Next up, we have regulatory bodies who enforce norms in the healthcare community primarily through licensing. So in the UK, we have the General Medical Council, who regulates physicians, as well as the Nursing and Midwifery Council, which is self-explanatory, and similar organizations for dentists, etc. Organizations like these can take away a professional's license to practice if they violate a community norm. So in this sense, these organizations can be considered pseudo-legal, as they are granted this authority to take away licenses through legislation, and their decisions are legally binding. Finally, the least authoritative of the types of legal instruments that I want to mention relates to professional organizations, like the British Society for Genetic Medicine. These bodies are relevant as they produce best practice guidelines, which might be relied upon in the negligence context. So what I mean by this is that if something goes wrong when a practitioner is dealing with a patient, and that patient decides to sue the practitioner for damages, the decision with regards to whether the practitioner acted in a negligent manner will be influenced by whether or not they adhered to the best practice guidelines laid out by their professional organization. So while following best practice guidelines is a good idea for lots of reasons, you might also consider that one day you may be relying on that kind of adherence as a legal defense. So now that we've gone through sources of law generally, I want to focus on the two most relevant of these sources for our current purposes, by which I mean some of the UK jurisprudence and law that is most relevant in the field of genetics. We're going to start with some leading jurisprudence, first on informed consent, which I think at this point is a concept that you're fairly familiar with. So compared to the US, to Canada, to Australia, the English common law has been somewhat reluctant to fully embrace the doctrine of informed consent. While the importance of providing information to enable autonomous decision-making has been recognized, exactly how much information to provide was for a long time measured by professional standards. That is to say that a lot of deference was given to physicians. So the Bolam principle, or the Bolam test, which I have noted here, is a principle that up until 2015 laid down the typical rule for assessing the appropriate standard of reasonable care in negligence cases involving skilled professionals, of course doctors. So the rule is that if a doctor reaches the standard of a responsible body of medical opinion, he is not negligent. So what this means is that if you have a situation in which the court is questioning whether a physician has acted in a negligent manner, they consider the standard of whether many doctors would have agreed that a particular action was not negligent, in which case the courts will defer to that opinion. So this principle was extended to the concept of informed consent in the Sideway case. So in that case, it was decided that the quality of information to be provided to a patient about a given treatment was to be left ultimately to the doctor's clinical judgment. So the courts would consider that there had been no breach of a doctor's duty of care to their patient and negligence, which means, I should say, duty of care refers to the sort of ethical responsibility, legal responsibility in this case, that a physician owes to their patient. So there would be no breach of the doctor's duty of care and negligence if the failure to warn of risks was accepted as proper by a responsible body of medical opinion. So again, the same standard, the courts defer to physicians in this kind of case. Fortunately, there's been some movement away from this standard in more recent cases. So we have a case that I don't have listed here, referred to as Chester and Ashfar from 2014, in which the judge stated that in modern law, medical paternalism no longer rules, and a patient has a prima facie right to be informed. So here we're moving away from this paradigm of medical paternalism, and the reasonable patient, sort of your typical patient, is emerging as the central figure in informed consent. So that means that doctors must now ensure that patients are aware of any material risks involved in a proposed treatment and of any reasonable alternatives. So we have this case called Montgomery, which definitively overturned Sideway. So in Montgomery, the judge said the test of materiality, so the test of whether a particular piece of information is relevant, is whether in the circumstances of the particular case, a reasonable person in the patient's position would likely attach significance to the risk, or the doctor is or should be reasonably aware that the particular patient would be likely to attach significance to it. So you can see the patient becoming the sort of central figure in the informed consent process, rather than it just being up to the doctor to decide what the patient needs to know. I should note that these cases don't refer specifically to the standard of care necessary with respect to genetic information. There are no cases specific to the genetic context that have yet made it to court. This is another reason why the law doesn't fully keep up with ethics, because you have to have a test case come to court before you can find out what a decision would be, what the law would be. So that said, the standard articulated in Montgomery would most likely be applied, or it would be the starting point anyway, if such a case did make it to court. Moving on, we're going to next discuss the law with regards to confidentiality, as it's articulated in UK jurisprudence. So, although as a cause of action, breach of confidentiality has developed judicially over many years, its principal elements have remained essentially the same since those originally formulated in Coco and Clark that I have listed here, which is a 1969 case. So essentially what we see here is that under the common law, individuals have a right to bring legal proceedings on the basis that the collection, use, and disclosure of personal information is in breach of the obligation of confidence. So essentially, anyone who receives confidential information must not disclose it without consent or some other reasonable justification. So although there is still some uncertainties surrounding the law in this area, in general it can be said that information is confidential and thus protected by the common law if it can be shown that three things are true. So first off, information is protected by the common law as confidential if that information has the necessary quality of confidence, which is to say that it's not in the public domain already and it has some measure of sensitivity and of significance. Secondly, information is protected if it was communicated in circumstances giving rise to an obligation of confidence. So such an obligation can be implied, for example, from the relationship between the parties, specifically a doctor-patient relationship, for example. Though in some less obvious circumstances, the nature of the communication should be assessed in light of the content of the information and whether the subject of the information had what we call a reasonable expectation of privacy. Third, information is protected by the common law as confidential if there was an unauthorized use of the information to the detriment of the party communicating it. So this means that the party seeking to have their information acknowledged as confidential has to show that they've suffered some kind of injury, like mental distress or some form of economic loss. So in order for information to be considered confidential and protected by law, it has to have those three characteristics. So another thing that we know from Coco and Clark is that there are some exceptions to the common law duty of confidentiality. So confidentiality is not an absolute right. So where there has been consent, when the information is trivial or already in the public domain, or when the information is in the public's interest, there's no duty of confidentiality that arises. So the common law establishes these sort of core principles, but there is still some uncertainty in untested contexts, for example, in the realm of genetic information. So this kind of means that decisions just need to be made on a case-by-case basis. One other thing I just want to quickly note is that the common law duty of confidentiality does extend to confidential information about deceased persons. That's relevant because we're going to be discussing legislation shortly that provides some sort of specific direction and distinction between the confidential information about living persons and deceased persons. So let's move on to a third area of jurisprudence that I want to talk about, which relates to the ownership of human tissues. So the law surrounding the ownership and control of human biological material remains remarkably uncertain, unfortunately. But one case that does shed a little bit of light on the issue is Yearworth and North Bristol NHS Trust from 2009. So to give you a bit of background on this case, and you don't need to write this down if you are taking notes, so appellants in this case claimed that they suffered psychiatric injury upon hearing that sperm maintained in the trust's storage bank had become damaged when storage equipment failed. The appellants were cancer patients who had banked sperm at the trust due to the risk of their treatment affecting their fertility. At first instance, so at the trial level, the court held that the sperm did not amount to the appellant's property and the damage to it did not constitute a personal injury. So this was in line with legal norms to date. Somewhat surprisingly, the case was appealed, and the Court of Appeal held that for the purposes of claims in negligence, the appellants had ownership in their sperm. So they said specifically that provisions of Section 3 and 4 of the Human Fertilization and Embryology Act, which we're going to be talking about shortly, under which the trust held the samples, did not amount to a derogation from ownership for the people from whom the sperm was taken. So this is a really interesting case in that it goes against the generally held legal norm that there can be no ownership in the human body. So it does leave some questions about what this means for other forms of human tissue, other forms of genetic material specifically, taken for different purposes. So we don't know, for example, what this means for human cells, for genetic samples. Legislation, as I mentioned, does provide a little bit of additional information, which I'm going to move on to now. So the first piece of relevant jurisprudence, as I mentioned, is the Human Tissue Act of 2004. So the HTA was implemented in 2006, and it provides a legal framework in England, Wales, and Northern Ireland for the regulation, storage, and use of what is termed relevant material for the living, and the removal, storage, and use of tissue from the deceased for what they call scheduled purposes, underpinned by consent from appropriate persons. So to give you a little bit of background on this, the Urwith case that I just talked about aside, ownership of human tissue is illustrated by the common law doctrine that there is no property in the human body. So there's no legal owner of a dead body, and of course no legal ownership of, so to speak, dead body parts. So instead of conferring property values on these kinds of objects, the law has focused on the definition of legal possession of the body, which is a concept describing a sort of transient guardianship in contrast to ownership. So this means that once tissue has been removed from the body with the consent of a patient, a practitioner previously might have been viewed by law as essentially having legal control of it. So generally it's considered unethical for hospitals to retain tissue for research purposes without consent, so the Human Tissue Act was conceptualized to address this problem. So a little more specifically now on the HTA itself. This act, as I mentioned, regulates what they call relevant material. So that's things like human cells, chromosome preparation and fixative, and dried blood spots. Two things that are excluded from regulation under the HTA are cell lines and extracted human DNA. So DNA that's already been extracted where the patient is not involved in the current research. So these things cover a lot of material and perhaps raise some questions as to the utility of the HTA, but we'll discuss that a little bit more later. So in the context of these materials, the HTA requires consent for a number of purposes, including obtaining scientific or medical information about a living or deceased person, which may be relevant to any other person, including a future person. So that is to say, of course, all genetic research and diagnostic work that is done using so-called relevant material. From competent patients, the HTA requires health practitioners to gain consent for the removal, use, and analysis of tissues, and after death, the HTA lays out from whom consent must be sought. So written consent is necessary for the removal, use, and analysis of post-mortem tissue. One other interesting thing that the HTA mentions is that it is legal to perform health-related research on anonymized material derived from living persons without their consent, as long as that research is approved by a research ethics committee. So this raises some interesting questions about how possible it is to anonymize genetic material, but that is a discussion for another time. All right, next we're going to discuss another piece of legislation, specifically the Data Protection Act of 1998. So this act came into force in 2000, and it relates to genetics primarily in the context of health professionals sharing genetic information between themselves for the purposes of treating related family members, and the consent that's necessary to engage in this beneficial practice. So the purpose of the Act is to protect the rights and privacy of individuals and to ensure that data about them are processed with their knowledge whenever possible. The Act covers specifically the removal, specifically personal data relating to living individuals, not deceased individuals. So this act provides a framework to govern the process of sharing genetic information between health professionals without the consent of those shown on a pedigree, if the processing is necessary for medical purposes. Medical purposes in this context includes preventative medicine, medical diagnosis, medical research, the provision of care and treatment, and the management of healthcare services. So fairly broad. The only information relevant to clinical purposes should be shared. So this means that if it's not necessarily necessary, for example, to share the names of the individuals whose genetic information you're interested in, physicians should avoid that. And additionally, physicians should inform their own patients that this might occur. So one thing to note is that consent required under the Data Protection Act is not exhaustive. As we saw previously, the common law also has a role to play in regulating consent. So in this context of confidentiality, I wanted to also mention the Human Rights Act of 1998, as it's relevant to this context. So the Act incorporates the European Convention on Human Rights into UK law. Article 8 of the Human Rights Act establishes a right to respect for privacy and family life. Article 8 underscores the duty to protect the privacy of individuals and to preserve the confidentiality of their health records. So the current understanding is that compliance with the Health Protection Act of 1998 and with the common law obligation of confidentiality should satisfy this obligation as laid out in the Human Rights Act. But the HRA does also specify that any proposals for setting aside the confidentiality rights of an individual or any actions that interfere with that right with respect to privacy of family life must be justified as being necessary to support legitimate aims, and it must be proportionate to the need for which it's occurring. So I think that sort of adds to what we've discussed so far. Right. Moving on, one last piece of legislation that I want to talk about. This one is a little bit sort of tangentially related to genetics, as it's mainly about in vitro fertilization, but it does relate somewhat in that it regulates aspects of genetic engineering. So for example, it's relevant to gene therapy at the pre-implantation stage. So this act provides for the establishment of the Human Fertilization and Embryology Authority, who is responsible for applying the regulations of the Human Fertilization and Embryology Act, and for licensing both IVF clinics and scientists carrying out research on human embryos. So according to the Act, only permitted embryos can be implanted into the uterus of a woman. An embryo is permitted if it has been created by the fertilization of an egg, produced or extracted from the ovaries of a woman, and whose nuclear or mitochondrial DNA has not been altered. Similarly, an embryo also has to be made from a sperm produced by or extracted from the testes of a man, and whose nuclear or mitochondrial DNA has not been altered. So exceptions can be accepted only to prevent the transmission of serious mitochondrial diseases. So this obviously sets some very real limits on the degree to which embryos can be genetically altered, which you may or may not agree with. The HFEA also controls what research can be done on embryos, both human and sort of transgenic human-animal hybrid embryos. Interestingly, it also defines motherhood in the context of embryo implantation as the woman carrying the fetus, who might not be the sort of genetic parent, is going to be considered the mother. It also defines the term father as the husband of the woman carrying the fetus unless he has not consented to the treatment. And of course this is the same for women in a civil partnership. For a woman in a civil partnership with a woman who is conceiving via IVF is by default the other parent unless they do not consent to the treatment. So I just thought this was interesting to raise as it's sort of an example where we see the construction of social relationships through legal definitions. I don't think it will come up sort of in our particular discussion about Henrietta Lacks, but I just thought it was an interesting thing to note. Okay. So far, we've discussed a bunch of different legal issues in genetics. We've looked at privacy, informed consent, confidentiality, ownership of human cells, etc. What I've said so far wraps up sort of the review that I wanted to do on that jurisprudence and legislation, though there are, of course, a number of other pieces that I could have described that you might come across in the course of your careers, but we just didn't have time to look at today. What we've discussed does hopefully give you some insight into how the practice of genetic medicine is regulated, and also into some of the gaps where the law has not quite caught up with the technological advances in the field. So now I want to give you a chance to apply some of what you've seen so far to the Henrietta Lacks case. In a moment, Catherine is going to pause this lecture, and you're going to have a discussion of the ways in which the legal instruments that we've discussed so far might apply to that case. So in having that discussion, I'd like you to try and focus on the legal rights and obligations that arise from the legislation and jurisprudence that we've looked at, sort of in contrast to the ethical issues raised by the case, though there are, of course, lots of those as well. So in some instances, you might identify an issue that you think ought to be regulated by the law, but that is not, and feel free to consider those also. Before you get started, I'm just going to do a quick recap of the Henrietta Lacks story and give you a little bit of extra background for those of you who don't know. So Henrietta Lacks is a black woman who was born in Virginia in 1920. On January 29th, 1951, Lacks went to Johns Hopkins Hospital to get a diagnosis for abnormal pain and bleeding in her abdomen. Physician Howard Jones quickly diagnosed her with cervical cancer. During her subsequent radiation treatments, doctors removed 2 cervical samples from Lacks without her knowledge. She died at Johns Hopkins on October 4th, 1951, at the age of 31. The cells from Lacks' tumor made their way to the laboratory of researcher Dr. George Otto Gay. Gay noticed an unusual quality in the cells. Unlike most cells, which survived only a few days in isolation, Lacks' cells were far more durable. Gay isolated and multiplied a specific cell, creating a cell line. He dubbed the resulting sample HeLa, derived from the name Henrietta Lacks. The HeLa cell line has been used in a wide variety of medical research. Jonas Salk used the HeLa strain to develop the polio vaccine, sparking mass interest in the cells. Scientists cloned the cells in 1955 as demand grew. Since that time, over 10,000 patents involving 10,000 patents involving HeLa cells have been registered. keep this in mind later during our discussion of patents. Researchers have used the cells to study disease and to test human sensitivity to new products and substances. The Lax family learned about the HeLa cells in the 1970s. In 1973, scientists contacted family members seeking blood samples and other genetic material. Inquiries from the family regarding the use of HeLa cells and publications that included their own genetic information were largely ignored. The case gained new visibility in 1998 when the BBC screened a documentary on the Lax case and HeLa, and Rebecca Skloot later wrote a popular book on the subject called The Immortal Life of Henrietta Lax, which I highly recommend. So the HeLa case has raised questions about the legality of using genetic materials without permission. Neither Lax nor her family granted permission to harvest her cells, which were then cloned and sold. It also raises questions about genetic privacy and consent. In 2013, German researchers published the genome of a strain of HeLa cells without permission from the Lax family. Since 2013, the Lax family has had limited success in gaining control of the HeLa strain. An agreement between the family and the National Institute of Health, for example, in America, granted the family acknowledgement in scientific papers and some oversight of the Lax genome. So I'm now going to leave it to you to discuss whether you think that this is a sufficient response, and additionally, if such a case were to come up in the UK today, what laws you think would apply and in what ways. So go ahead and pause this video now. All right. So now that you've had some time to discuss the legal issues that we went over earlier in this lecture in relation to the Lax case, I'm going to review a few of the topics that you might have discussed, though I'm sure you thought of many others in addition to the ones that I'm going to mention now. So to start, there are a few sort of larger questions that might have come up as helpful in framing your discussions. So we can ask, for example, what exactly human cells are that we would want to accord them the kind of legal protections that we've been discussing this morning. So are human cells nothing more than receptacles for sensitive personal health information, and so subject to all the same rigorous consent and privacy norms as health information is? Or are they something more than that, that ought to have some kind of additional protection or maybe protection of a different nature? So in considering that kind of big picture question, we can look at the specific legislation and jurisprudence that we went over earlier today in relation to this case. So one thing you might have talked about is the Human Tissues Act. And so we know from that act that today the doctors at Johns Hopkins would have been required to obtain consent from Lax in order to conduct research on her cells. Arguably, now that the cells have been transformed into a cell line, consent is no longer required for research using the HeLa cells, since the Act, as I mentioned, excludes cell lines. Given the fact that research on the HeLa cells can still reveal sensitive information about the Lax family, as you saw in your readings, it's debatable whether this is an appropriate restriction, an appropriate limitation in that act. We also saw in Yearworth, the case that I mentioned in relation to the banking of sperm by cancer patients, that British courts are starting to reconsider the traditional legal principle that there's no ownership in human in human tissues. While it's not clear exactly the degree to which this case might be extrapolated to contexts involving other kinds of tissue, maybe you considered what the implications of ownership of such tissues might be for genetic research. One thing, for example, you might have considered is what implications ownership would have when those tissues are commercialized in the way that the HeLa cells were. So the question there is whether the Lax family should have received any financial compensation for the sale of the HeLa cell line, or not. So we can also ask, considering the Montgomery case that I raised earlier, whether if Henrietta Lacks was in the same situation today, what kind of information her doctor would have been required to provide to her in order to gain her consent for research. You can consider, for example, what you think Lacks would have needed to know in order to fully consent to what has since been done with the HeLa cell line, or whether you think she even could have given true consent at all, given the broad array of research projects that her cells have since been used for. So a couple of other things that you might have considered with respect to issues of privacy and confidentiality. We need to think about how the Lacks case is complicated by the fact that the private information with which we're currently concerned is not just that of Lacks herself, but also that of members of her family, who have had personal information about themselves revealed as a result of the HeLa genome being published. So this means that we need to consider what, if any, interests biological relatives have in the use of samples and in the publication of genetic data. It goes without saying that due to the unique nature of genetic information, publication of an individual's sequence has implications for that person's biological relatives. There's some emerging consensus amongst ethicists that, emerging consent amongst ethicists that researchers should obtain consent from the family in cases like HeLa, but it's not yet clear whether the law requires this. So, in fact, the law does not require this. It's not clear whether the law ought to require this. So this raises some difficult questions, such as from whom would consent in such a situation be required? So what degree of family member, degree of biological relation do you have to possess in order to be asked for consent? It also raises issues about what to do if there's disagreement amongst family members. So would it be the case that if one immediate descendant of Henrietta Lacks said, no, they didn't want the genome published, would that mean that it could just not be published, period? There's also some potential here to severely constrain research by making consent just too labor-intensive and expensive to obtain. So this illustrates that there's some tension between the desire to produce valuable research in a timely manner, and on the other hand, on the other side, the obligation to respect patient autonomy. And I'm sure that you've seen this kind of tension come up a number of times throughout this course already, so I'll leave it there for you to consider. Another thing that you might have considered in your discussion, as I have listed here on this slide, is that the Data Protection Act, the Human Rights Act, and the case of Coco and Clark have all provided some direction with respect to these issues. That said, I would say that this is an issue, specifically the obligation owed to biological relatives with respect to genetic research, that is not well explored in the law. And it's perhaps a place where additional legal guidance or regulation might be needed. So again, while I'm sure that you discussed and considered many other issues in addition to those that I've just mentioned, I think that that's all we have time for now. So that's all for me for the moment. I'd like to thank Catherine for inviting me to give these lectures and apologize that I was not able to come and give them in person. So thank you for listening. Please don't hesitate to send me an email if you have any follow-up questions to this lecture, and I'll be speaking to you again later today in relation to patents. Thanks.